Namaste, my dear friends, brothers, sisters, ladies, gentlemen, students, scholars, teachers, trainers, professors, professionals, all readers, writers, listeners, speakers, those who are listening, watching YouTube channel 3M Creator, I heartily, cordially welcome. Dear friends, now we will discuss very important, knowledgeable, informative, instructive and directive. As earlier we have started law and social transformation. For the scholars of LLM, they must listen. Let us describe how the right to education is accepted as fundamental right of children in India. Let us discuss the efforts made by state in this regard. Education is important for the personality development. A person's mental or intellectual development is not possible without education. The lack of education gives birth to many bad practices, bad uses, or superstitions. Uneducation is reason of economic backwardness. So far, the overall development of person education is important. But the sad part of but the sad part is that the ratio of educated population in our country is very less. Most of people are uneducated and illiterate in village. This is the main reason of their backwardness. Even after the 50 years of independence of India, there is no such provision of compulsory education for children. So no one can think of free education. Constitution provides the right to education and culture, but has no provision of free education for children. In short, right to education has become a formality. What are the fundamental rights? Finally, after 86th Amendment of Constitution in 2002, a new Article 21A was added which placed the education as a fundamental right. Article 21A says that free and compulsory education of all children in the age group of 6 to 14 years as a fundamental right in such a manner as the state may by law determine. Such as according to Article 21, the provision of free and compulsory education was made for the child of 6 to 14 years. Unikrishnan versus State of Andhra Pradesh 1993 for SCC 645 in this matter. Very earlier Supreme Court declared the education as a fundamental right for the children till 14 years of age. And in Punjab, Rao Nahati versus State of Maharashtra EIR 2011 NOC 109 Bombay. In this matter, Bombay High Court said that right to education is a fundamental right. It is duty of state to make arrangements of education for the children of all classes. It is also the duty of parents too. It is expected from competent government or local authority to establish educational institutes at such places where nearby no such educational institution is established. Indian Service Society Trust versus Yogesh Bhai Lal Patel AIR 2012 SC 3285. In this matter, Supreme Court said that right to education is an important fundamental right. It is duty of court to arrange preliminary education for children. Society for Unaided Private Schools of Rajasthan versus Union of India AIR 2012 SC 3445. In this matter, Supreme Court said that Article 21A provides power to state class to make clauses for free and compulsory education. According to right of children to free and compulsory education Act 2009, to this act provision has been made of free and compulsory education for the child age of 6 to 14 years. Section 3 says that every child of the age of 6 to 14 years shall have the right to free and compulsory education in a neighborhood school till completion of elementary education. Further, it is said that no fees, charges, expenses shall be recorded from such children. Section 8 says that the appropriate government shall provide free and compulsory elementary to every child, such as duty has been imposed on competent government that it shall provide free and compulsory elementary education to every child of 6 to 14 years. Do not take fees, charges, or any expenses from them. Provide school building for them. Tribal mission Vitaliki versus State of Kerala EIR 2011 NOC 26 Kerala. In this matter, it was said that it is violation of Article 21A to deny from recognition to any school due to having already a school in labor. Niranjan Mishra versus Union of India EIR 2013 NOC 317 Odisha. It was considered as a violation of Article 21A, recover the increased amount of compulsory recovered. It was considered as violation of Article 21A, required the increased amount of computers from children by School Development Committee. Environment and Consumer Protection Foundation versus Delhi Administration EIR 2013 SC 1111. In this matter, Supreme Court decided that all necessary requirements must be provided in schools. Sanitary system for girls and boys, drinking water, sufficient classrooms, teachers and other staff, etc. Supreme Court gave directions to every school in this regard. such as adequate publication of education is done by establishing education as a fundamental right in Constitution. Our Constitution prohibits the discrimination on the basis of caste. Let us discuss the statement. What provisions are given in Constitution for the protection from caste discrimination? Let's discuss the law made for the prevention of atrocities over scheduled caste and scheduled tribes and to end the discrimination of caste. India is a country of various castes, religions or cultures. Various castes have deep effect of social surroundings. Many castes where works do works to divide the nation at the same place, some becomes the example of unity and harmony. India is its unique example. There are many castes in India, but still here the atmosphere of harmony and unity. Its main reason is that our constitution or other laws provides local protection to castes. In our constitution, provision has been provided for the protection of the rights of minorities and other castes. Constitutional protection has been provided to scheduled castes, scheduled tribes, backward classes or minorities. Reservation system is made for the elevation or rise of these castes. These systems made a wide change in social surroundings. The laws related to caste and community provided a new way to the society. Prohibition of discrimination on the basis of caste. Many provisions are provided regarding prohibition of discrimination on the basis of caste. Article 14 says about the equality before law or equal protection of the laws. It means that law is equal for every person and every person has equal protection of laws. According to Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Article 15 says that states shall not discrimination on grounds of religion, race, caste, sex, place of birth, or any of them. No citizen shall, on grounds of religion, race, caste, sex, place of birth, be subject to any discrimination to entry into any public place. Special provisions can be made for women or children. Special provisions can be made for scheduled caste or scheduled tribes. It is clear that states shall not discriminate on the basis of religion, caste, sex, place of birth, etc. Dr. M.C. Sharma versus Punjab University, Chandigarh PIR 1997, Punjab and Haryana 87. In this matter, it was considered unconstitutional on the basis of discrimination that in any women college principal should be women only. Srimati Rajkumar Avasti versus State of Uttar Pradesh EIR 2008 NOC 1859 Allahabad. In this matter, denial for denial for maintenance too. One is for unmarried, not minor, who is unable to maintain herself. Daughter was considered against the feeling of constitution. Any citizen cannot be prohibited to enter into any shop, public restaurant, hotel, public place of entertainment or well, pond, road or other places dedicated to the use of general public. A new revolution was started after this system in society. Self-confidence raised in people of scheduled caste, scheduled tribes or other backward classes due to the provisions made against the caste, other backward classes due to the provisions made against the caste discrimination. Special arrangements for certain castes and classes. Constitution has provision to make laws for the elevation and rise of certain classes and castes according to Article 14,815. States shall make laws for the protection of rights and rise of scheduled castes, scheduled tribes, women, child, other backward classes, and such laws shall be constitutional. The reason of this is the difference of condition of these castes from others. For example, for the protection of women from domestic violence in 2005, an act was passed named Protection of Women from Domestic Violence. It was considered constitutional. The Palraj vs. Union of India AIR 2009 NOC 2540 Madras. Dr. Ramkrishnan Balotia vs. Union of India AIR 1994 Madhya Pradesh 143. This matter. Scheduled Caste and Scheduled Tribes Prevention from Atrocities Act 1989 was considered constitutional. Mahalakshmi Tinku vs. State Bank of India AIR 2009 Jammu and Kashmir 67 in this matter. The rules of bank which does not entitle the mother of degrees to get pension was considered unconstitutional. The only important thing is that such laws must not be depend upon willfulness, unreasonable classification. What is reservation? The system of reservation is an important step towards social revolution. Reservation has done comprehensive changements in social rulings. This system provided opportunity to the caste which was backward since many years. It is provision in Article 16 of Constitution that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office of the state. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, discriminated against in respect or any employment or office under the state. This system provides equal opportunity of employment to people of all castes and classes. That is, prohibits the discrimination in employment on the basis of caste. But it has an exception. Reservation according to this provision of reservation can be made for employment to scheduled castes, scheduled tribes, backward classes, women, and such provisions made for the development and rise of these castes shall be considered constitutional. 1707th Amendment Act 1995 of Constitution confirms this. Provisions of reduction in age or fees for the candidates of reserved cost have been done for those who sit in examination. Jitendra Kumar Singh vs. State of Uttar Pradesh, AR 2010 SC 1851, End of Touchability. End of Touchability is also a revolutionary step. According to Article 11, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability around arising out of untouchability shall be an offence punishable in accordance with law, such as in Article 17. End of touchability forbidden of its practice in any form is punishable offence. Devraj versus Padmana AIR 1958, Masood 1884. In this matter, Masood High Court considered the untouched ability as a social evil or bad practice. Abolition of titles. Article 18 abolishes the title. It is said that state shall not confer any title except military or academic distinction. No citizen of India shall accept any title from any foreign state. No person holding any office of profit or trust under the state shall, without the consent of the President, accept any present, emolument, or office of any kind, form, or under any foreign state. Balaji Raghavan versus Union of India, year 1996, FC 770. In this matter, in this matter, Supreme Court decided that Bharat Ratna, Padam Vibhushna, Bharat Ratna, Padam Vibhushan, Padam Bhushan, Padam Shri are not title. These are only ornamentation. But these cannot be used with names, such as it is one more important system to prohibit the discrimination. Administration of scheduled caste and tribe areas. The problems of scheduled caste and tribal areas are different from other places. This is due to the difference of culture and language of these castes. So provision has been made for the protection and welfare of their rights in Article 244 and 244A. Provisions of Schedule 586 are issued for their administration. Governor can make regulation for these areas. Ram Kirpal Bhagwan versus State of Bihar 1969 3SS SCC 477 1. Tribes Advisory Council. The system of establishment of Tribes Advisory Council for every state of scheduled areas has been made. Such council shall advise the governor for the welfare and rights of scheduled tribes of related state which has been delegated to it. Atrocity Prevention Law. Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 was passed for the prevention of atrocities over scheduled caste and tribes people. In this following acts done against scheduled caste or scheduled tribes are considered punishable offence. One is forces to drink or eat any inedible or obnoxious substances. Two is cause injury or insult by dumping excrete, waste matter, carcasses or any other obnoxious substance in his premises or neighborhood. He removes clothes or parades him naked or with painted fish, or is wrongfully disposes him from him land or premises, compels or entices to do begar, forces to not to work or to work, institute false, malicious or vexation suit or legal proceedings against him, intentionally insult or intimidates by using force or assaults, dishonor or outrage the modesty of women, corrupts or foul the water of any spring, reservoir or other sources, sexual harassment of women, denies from the use of any public place, forced to leave his house, village or other places of residence, presenting false evidence against them, special courts provision has been made for the trial of such offences. Ganguly Ashok versus State of Andhra Pradesh 2003 Law General 819 SC. Such an effective efforts has been done for social transformation by caste-related laws or constitutional provisions. What do you understand by gender inequalities? What are the reasons of gender inequalities? Let us describe the remedy to repudiate it. What is gender equality? What is gender inequality? How many type of this? Describe the reason. Let's describe the reason and remedy of gender inequality. Let's describe in detail about gender inequality. We can call gender difference as gender inequality or gender injustice. It is a burning problem of today's world. In male dominated world, women always stands at second place. She gets ignored. She was victim of exploitation and atrocity. She always becomes subject of discrimination in family or society. Like man, she neither has freedom nor facilities. This is gender inequality. Gender inequality reflects from following things. In families, boys are given priority than girls. Less consideration of women education. Less share in property than males. Women are not free like men. Economically, women are dependent over men. Girls' foeticide is committed. Women become subject to dowry debt. Women tolerates unbearable pain as a window. Widow generally cannot do remarriage or second marriage, but widower does remarriage easily. There are many things which shows discrimination towards women. This shows gender inequality. Gender inequality means discrimination between men and women and giving second place to women. Gender inequalities refer to the oblivious or hidden disparities among individuals based on the gender. This problem is known as gender bias. It is simple terms means the gender stratification or making difference between a male or a female. Types of gender inequality. These are many types of gender inequality like natality inequality. In natality inequality, boys are given priority than girls. That is, in natality inequality, boys are given priority than girls, etc. Boys are given importance. It includes male-dominated society. Male birth is expected rather than female. Boy's birth is celebrated, where the girl child birth spreads sorrow. Then female foeticide is also committed if knowledge that the child is that the child involved is female. In short, girls are considered as cursed. It starts from birth. Professional inequality. Second, gender inequality between male and female is professional inequality. Generally, females does not do profession. Easily, they cannot get any adequate profession. In various installations, factories, companies also gives priority to males. Women are not considered eligible for work. Even if women gets employment, then they are given less salary than men. Ownership related gender inequality. Gender inequality can also be seen in ownership of property related matters. In many countries or society, women do not have share in property or gets very nominal share. It also has many examples like generally the transaction of property is done by name of male. Women has no participation in various business. Proprie- Proprietorship is also related to men. Women does not participate in business. Generally, no farm is constituted on women's name. The social and economic development of women gets stopped due to ownership-related gender inequality, householder-related gender inequality. Our social system divide the work between male and female. Males take care of outer work while women take care of householder work. Household work is much important than outer work, business, trade, job. It is also non-productive. Women get bounded in the work of kitchen only. They do not get chance to see the outer world. Other gender inequalities. Gender inequality has many more types like keeping women privately, no opportunity for women to get higher education, no participation of women in jobs or trade, no freedom of visiting to women, obeying the women shamed by females. Reasons. Gender inequality has many reasons. Here types of gender inequality also shows the reasons of it. Gender inequality has following reasons: lack of education, dependency on men, non-participation in business, physical weakness, excess expense during marriage, going to another family after marriage. Economically, women are considered burden. Economically, women are considered burden of family. Obey women shame elements. No importance of women in constitution. No importance of women in continuing ancestry. No participation of women in social or cultural activity. Less participation of women in religious ceremonies. Remedies to repudiate. In today's democratic world, repudiation of gender inequality is essential. Although gender inequality is spoke over democracy, no country can be called fully democratic or developed if it has gender inequality. Social transformation is possible by repudiation of gender inequality. The remedies to repudiation the gender inequality are following. One is changement in mentality. Firstly, mentality should be changed to remove the gender inequality. We must have to end the dual mentality related to women. A thought that male and female are equal is need to develop. Women should be given respect in family. Their negligence should be removed. Their equal participation in family must make sure. Until we don't change our mentality towards women, we cannot remove the gender inequality in real sense. Real sense. Prohibition on female feticide. It is a clear example of gender inequality to kill female feticide fighters by considering girls as girls. So we must stop female feticide, such as celebration is done on the birth of baby, on the birth of boy baby. Similarly, same surroundings must be made on the birth of girl baby. This celebration must be done by considering them goddess Durga, Saraswati, Lakshmi, Queen of Jhansi, Meena, etc. It is also important to make the prevention of female Foeticide act harder, practice of sex discrimination should be strictly prohibited. The decreasing ration of girls is a challenge towards society. Employment opportunity. It is necessary to make women self-dependent and self-reliant to remove gender inequality. Man's thinking cannot be changed until women become self-dependent, so it is necessary that employment should be given to women. They must be inspired or encouraged to do business or trade. They must be given place in government or non-government jobs. They must be inspired to do part-time job. Their participation must be made sure in industries or industrial institutions. They must be given adequate economic autonomy. Equal pay for equal work. Different in the salary or alliance between male and female for equal work is an important reason of gender inequality. Generally, it is a conception that women do not have equal ability to do any work like men. That's why they are given less salary than men. This develops the feeling of inferiority complex, and women do not want to do work. The situation is that today in many fields women are more capable than men. In many occupations they have monopoly except this all it is not lawful to give them less salary than men. So the principle of equal pay for equal work must be applied. Power sharing. Gender inequality can be removed by sharing of women in power. Till now the participation of women in power was very less. They were not considered eligible for power. It is our wrong concept. Now India had its women prime minister or president also. So women's place must be reserved in power. Their percentage must be made sure in parliament, state legislature or in local institutions, panchayats or municipalities, etc. Participation in power will enhance the self-confidence and self-respect in women. Higher education. Women are very backward in education. Many women are not even not even literate. The ratio of higher education is nil. In our culture, the area of women is limited to the kitchen or house. The mentality is this that a girl will go to another home after marriage. So why should they be educated or why money must spend over them? This mentality has to be changed. Women has to inspire for higher education. They will have to be doctor. They will have to be doctor. They will have to be an engineer. They will have to be administrative officer. They will have to be advocate or judge, etc. Women organizations. Women organizations are too very effective to remove the gender inequality. Women must be inspired to make their organization. The benefit of these organizations must be shared. Courage and self-confidence will enhance in women. They can do struggle against the exploitation or atrocity over them. They can step into the world of employment. The feeling of social services will build in them. This will encourage women to be aware about the girl. This will encourage women to be aware about their rights. They make they make become participants in power. They can take breathe in open air, out from house. The feeling of self-respect, self-dependent and self-reliant can develop in them. Social evil or bad practices can be eliminated, etc. There are many more remedies to remove gender inequality. The only need is to be committed for this. Indian panorama. It is good that after independence, efforts are made in India to remove gender inequality. The efforts to remove gender inequality clearly shows in legislation, constitution, or in judicial decisions. Equality before law. Adequate efforts are made in our constitution to remove gender inequality. According to Article 14, equality before law or equal protection of law has been given to all. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Article 14 does not have discrimination on the basis of sex. Article 15 says that the state shall not discriminate against any citizen or ground only of religion, race, caste, sex, place of birth, or any of them. Dr. M.C. Sharma versus Punjabi University, Chandigarh PIR 1997, Punjab and Haryana 87. In this article, discrimination on the ground of sex is considered unconstitutional. Srimati A. Bracknell versus State AIR 1952, Allahabad 17,746. In this matter, it was decided that women cannot be deprived from keeping and disposing property on her being a woman. Sorry. Equal opportunity for employment. Article 16.2 says that no citizen shall, on grounds only of religion, race, caste, sex, nation, places of birth, residence, or any of them, be ineligible for or discriminated against in respect or any employment or office under the state. Such as Article 16 provides equal work opportunity to both male and female. Equal pay for equal work. The provision pay for equal work is made to remove the gender inequality. No discrimination regarding payment can be made between male and female. Uttarakhand Women Welfare Council versus State of Uttar Pradesh, AIR 1992 SC 1965. In this matter, challenge was given to the discrimination of salary between male or female working on equal posts. Supreme Court considered it unconstitutional and said that women should be given equal payment like men. Prohibition of female ferticide. Female ferticide has been considered as punishable offence in India. Along with this, the test of sex determination is also considered as an offence. Section 315 of Indian Penal Code 1860 considers that to stop childbirth is a punishable offence. It is fetus killing related subject. Radiological and Imaging Association versus Union of India, AIR 2011, Bombay 171. In this matter, Bombay High Court said that sex determination is prohibited under Preconception and Prenatal Prohibition of Sex Determination Act 1994, and the sonography of pregnant women can be done for special purpose only. Right to property through Hindu Succession Amendment Act 2005, revolutionary changes were made in the transfer of Mitrakaksha property. Now provision is made that the daughter shall also be like a co-partner after at the time of implementation of Hindu Succession Amendment Act 2005 by Mitraksha law in joint Hindu family from birth like a son, daughter will be a co-partner from her personal rights. She shall have the same rights in co-partner property like a son. She shall have the same liability in co-partner property like a son. Vishakha versus State of Rajasthan, AIR 1997, SC 30 under 11. In this matter, important directions were given by Supreme Court regarding the exploitation of working women, such as effective efforts were made in India to remove the gender inequality. Powerful race has been gained by social transformation due to laws made for repudiation of general inequality. Tomorrow we will discuss the main crimes commits against women, what remedies have been done to prevent these crimes. Now you are listening Constitution of India, new challenges. Let us discuss the India Independence Act 1947 is considered an important legislation ensuring the process of transfer of power. Consider this statement. Let us mention the main provisions of the Independence of India Act 1947. An important task was to ensure the process of transfer of power according to the plan of Lord Mountbatten before independence. For its implementation, a bill was introduced in the British Parliament on July 5, 1947, which was passed on July 18, 1947. This bill, this bill came to be known as the Indian Independence Act 1947. Provision. The Indian Independence Act 1947 was a concise legislation, etc. Act in which there were a total of 20 sections and 2 appendices. The following arrangements were made in this section. One is, in section 1, this provision was made that by dividing India, two dominions of India and Pakistan should be established. Powers, Power was transferred by the Governor of General to Pakistan on 14th August 1947 and to India on 15th August 1947. After 14th August 1947, the British government will not have any right over these two dominions. There will be separate Governor Generals for both the dominions who will be appointed by the Emperor of England. The boundaries of both the dominions should be fixed from the areas that were part of British India. The following areas should be included in Pakistan. Designated areas of East Bengal and the West Punjab, the province of Sindh and designated areas of British Balochistan and such areas of the northwest frontier provinces whose representatives had accepted to be included in the Constitution Making Committee of Pakistan. Apart from these, the remaining areas should be included in the Dominion of India. In section 3 and 4, provision was made regarding the division of Bengal, Punjab and Assam on the basis of plebiscite and the determination of their boundaries. Both the Dominions and India and Pakistan will have the right to make constitution for them, and until such constitution is made, the governments of both the countries will work under the Government of India Act 1935. The post of India Secretary was abolished and the post of Commonwealth Secretary was created in its place. Both the dominions were given full legislative powers. The Governor General was given the power to issue ordinances. The officials of the civil services appointed by the Secretary of India will continue to serve in the new dominion after the transfer of power, and there will be no adverse change in their service conditions. The division of the armed forces of India between the two dominions will be done by the Governor General, and until they are divided, they will be under the control of the Governor General. Pakistan will be able to constitute a constitution making committee to make a constitution for its share. The work of negotiation and settlement with the tribes of the Northwest Frontier province will be continued by the successor states. As soon as India Independence Act 1947 is implemented, India will be completely free from the control of the British government. The existing laws so far shall remain in force in the dominions till their circumstances suit. Effect. The most important effect of the India Independence Act 1947 is India's getting freed from British power forever. India breathed fresh air after a long period of slavery. This was a great achievement for India. The Indian system of governance was widely affected by the India Independence Act 1947. It is the effect of this act itself that now those laws could be repealed or amended by the legislatures of India and Pakistan, which were implemented by the British government. For this, there was no longer any need for the approval of the British monarch or parliament. The officials and servants of the dominions of India and Pakistan had to pledge their allegiance to the respective constitution of the respective dominions and not to the British dominions. Now, the Executive Council of the Governor General had ceased to exist. He now had to act according to the advice of the Council of Ministers. The Governor General of Pakistan could intervene in the appointment of the ministers of the province and remove them, but the Governor General of India had no such jurisdiction. Now the Constituent Assembly used to do the work of the legislation. It had a speaker and a deputy speaker. Now the prior permission of the Governor General was not required to make laws on any subject. Now it was no longer necessary to conduct the proceedings of the central and provincial legislatures in English. No person could simultaneously be a member of the provincial legislature of one dominion and a member of the Constituent Assembly of another dominion. The jurisdiction of the Calcutta and Labour High Courts was extended to West Bengal and West Punjab respectively. Governor General could make laws on any provincial subject in case of emergency. So, separate high courts to be set up for East Bengal and East Punjab. Now the Union Jack flag was no longer of any importance for India and Pakistan. Now the Union Jack flag was no longer of any importance for India and Pakistan. Now India's protection from the officers of the civil service had ended. Now they had become under the respective dominions. Thus, there was a radical change in the governance system by the India Independence Act 1947. Changes. With the coming into effect of the Indian Independence Act 1947, it became necessary to make the following changes in the Government of India Act 1935. With the British monarch's government having no control over India, Section 3 of Government of India Act 1935 had to be abolished to facilitate the establishment of the dominion in India on 15 August 1947. Section 5 of the Government of India Act 1935 had to be amended. Section 11 to 15 of the Government of India Act 1935 had to be repealed. These sections were in relation to the following: reserved subject specific responsibilities of the Governor General, supervisory powers of India Secretary, Financial Advisor to Governor General, etc. Due to the legislative powers of the central legislature being vested in the Constitutional Assembly, the relevant provisions in Government of India Act 1935 had to be abolished. Provisions related to the specific responsibility of provisional provincial governor generals had to be removed. State of the country. With the passing of the Indian Independence Act 1947, the treaties between the native states and the British government were ended. British sovereignty came to an end to them. In fact, the native states became independent now. These native states were expected to join India or Pakistan. The rulers of Hyderabad and Travancore declared themselves to remain as sovereign state. An attempt was made by Lord Mountbatten to merge the princely states of Hyderabad, Junagadh, and Kashmir into India, but they did not succeed. Membership of the Commonwealth. After independence, the question before India was whether or not to join the British Commonwealth. India feared that if it is India feared that if it accepted membership of the British Commonwealth, England would continue to rule over it. But India's doubts were resolved with the announcement of Henderson, the then Deputy Secretary of India, that the British Commonwealth is not a static institution but a developing one. Earlier it was controlled by the British monarch, but now independent nations cooperate with each other, inspired by common interest and ideals. Let us explain the various characteristics of the Constitution of India. The Constitution of India is a pious document. It contains the characteristics of a famous Constitution of the world. It is a result of continuous effort of 2 years, 11 months, 18 days, study, consultation, thinking, and hard labor of the Constituent Assembly. It was made applicable to whole of India on 26 January 1950. The main characteristics of the Constitution of India are as under the lengthiest constitution. One is the lengthiest constitution. Generally, the constitutions are in small size. Major elements are mentioned in the constitution and other things remain for interpretation. But the Constitution of India is an exception to this. The size of the Constitution of India is neither too small nor too large. While mentioning the necessary things in it, it has been kept in balanced size. There were 395 articles, 22 parts, 12 scheduled in the original text, which increased later due to amendments from time to time. In the words of Sir Ivor Jennings, the Constitution of India is largest and detailed constitution of the world. The critics called it as the paradise of the advocates. Established establishment. Establishment of sovereign democratic republic. The main characteristic of our constitution is established of sovereign democratic republic. Main characteristic of our constitution is establishment of sovereign democratic republic. It has been said to be as sovereign because it is sovereignty is not vested in upon entity, but vested in the people of India. Now it is completely free from outside control. India determine and control its internal and external policies. Democracy has been established in India. Democracy has been established in India. Here, government is secured under the people. It proves well of the democracy as here the government is of people, for the people and conducted by the people. Its main object is public welfare. Socialism and secularism. Our constitution is nurture of socialism and secularism. It realizes the dream of building socialist society of the father of nation Mahatma Gandhi. Social, economic and political justice has been summoned in its framework. It propounds the principle of equality by finishing all kinds of diversifications, by extracting right to property from the fundamental rights, establishing it as general constitutional rights, confirms its socialist form. However, our constitution is also a conductor of secularism constitution. All religions are equally recognized in it. Every person has freedom of his inner soul and do adopt religion undoubtedly, conduct and publicize. It does not impose Raj Dharma upon any person. It is to mention that the expression socialism and secularism was not appearing in the original text of the Constitution. This has been inserted in the Constitution by the 42nd Amendment. Origin of origin of parliamentary form of government. India is a union of the states. The Constitution at here is federative. The Constitution of the, the federative Constitution is also of two kinds, presidential and parliamentary. In the presidential government system, the president is the supreme, as in the case of America, whereas in the parliamentary government system, the actual government based in the hands of people. The government is of people, for the people, and conduct, conducted by the people. The representatives of the people conduct the government as council of ministers. Parliamentary form of government has been adopted in India. Here the actual governance of the government is safe in the hands of members elected by the people. The president is the chief of the country, but only nominal. He does all works in the advice of the council of ministers. Fundamental rights. The important characteristic and achievement of the Constitution of India is that of containing fundamental rights. These fundamental rights are like a boon and gift for the Indians who remained under servility for long years. The main object of these fundamental rights is to the main objects the main object of these fundamental rights is make available opportunities for all round development of the citizens of India. The following fundamental rights are mentioned under Part 3 of the Constitution. Right to equality, right to freedom, protection of life and personal liberty, protection against arrest and detention, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. It is mentioned here that the right to property was initially a fundamental right, but later on it has been categorized as a constitutional right by an amendment. The right to freedom itself an important fundamental right. The following freedoms to the citizens have been mentioned under the Article 19 of the Constitution. To speech and expression, to assemble peace, to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, to practice any profession or to carry on any occupation, trade or business. Fundamental duties. Fundamental duties were not mentioned in the original text of the Constitution. Fundamental rights were added in the Constitution, but not the fundamental duties. Later on, it has been felt necessary that the fundamental duties be also inserted. As a result of this, the following fundamental duties were prescribed in the Article 51A by inserting a new Part 4A in the Constitution by 42nd Amendment. It shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for giving creatures, to develop the scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. Who is a parent or guardian to provide opportunities for education to his child, or as the case may be, bird between the age of 6 and 14 years. Directive principles of state policy. Our constitution, fra- our constitution framers assumed for such a structure of the constitution which should be proved welfare for the human. The constitution framers were of the view that the states should determine their policies in this way so that status of life of each person may rise. The education to children. Nobody may be denied for the justice due to lack of money, availability of equal pay for equal work to all, economically strengthened in old age and sickness, more decentralization of entity, etc. Implementation of these welfare provisions were not made essential, but it was upon the states as per their economic resources. This is the reason that these have not been named as fundamental rights, but called as directive principle of state policy. These directive principles of state policy, these directive principles of state policy are mentioned in Part 4 of the Constitution. Although the state is not bound to implement these directive principles of state policy, but being a welfare state, it is moral duty of the states that they implement as maximum it can be. With the pass of time, so many decisions have been passed by the courts which give the standard of fundamental rights to these directive principles of state policy. Coordination of rigidness and flexibility. It will not be out of place to mention here that the Constitution of India is neither too rigid nor too flexible as far as concerned with the as far as concerned with the amendment. Such a procedure of an amendment in our Constitution has been adopted, which is neither too rigid as in the case of America, nor too flexible as in the case of England. Provisions for making amendments according to country, time, and circumstances are made in it. This is the proof of the fact that only 85 amendments are made in it upon the year 2001. Adult suffrage, as we have seen above, parliamentary form of government has been adopted in India. The actual governance of the India, the actual governance of the government is safe in the hands of members elected by the people. The representatives of the people are elected by the people. The right to elect has been provided in the Constitution to such every person who is adult, that is, who has completed the age of 18 years. It has been named as adult suffrage under the Article 326 of the Constitution. One essential thing is that there is no discrimination with regard to right to vote on the basis of gender, caste, gender, etc. This is a unique characteristic of its Constitution of India, the, the Constitution of India. Freedom of an independent judiciary. Judiciary is an important pillar of the democracy. This is the safeguard of fundamental rights of the citizens. Safety of the Constitution is also the responsibility of the judiciary. Independence of such judiciary is essential. It is a matter of pleasure that independence of the judiciary is considered the basic structure of the Constitution, which cannot be tempered. Single citizenship. One more unique characteristic of our Constitution is of its provision of single citizenship. Here, each citizen is called as a citizen of India. We cannot claim for double citizenship as in America. Decentralization of power. The Constitution of India believes in decentralization of powers. These powers are vested in the hands of the people and not in a person. Panchayati Raj system is the best example of it. This has been more strengthened by 73rd Amendment Act 1992. In this way, the Constitution of India is a unique, remarkable constitution. It may be said to be one of the ideal constitution of the world. Tomorrow we will discuss the Constitution of India. The Constitution of India is neither federal nor purely unitary, but it is a unique combination of both. We will discuss tomorrow. Thank you for continuing presence. Judicial process. Let us mention in brief the British judicial system. The judicial system and judicial process of India is from the British judicial system and judicial process. The origin of British judicial system is considered from the year 1600 along with the establishment of East India Company. Initially, the main aim of the company was to carry out business in India, but slowly it involved itself in the scope of law and justice. First of all, the legal and judicial rights were given to the company in Surat by issuing a notice by James I in the year 1915. The powers to decide the suits were delegated to the Samrat and Kaji. Settlement Act Regulating Act 1773. A Supreme Court was established in Calcutta by the Regulating Act in the year 1773. The powers to make law were delegated to the Governor General in Council. Judicial control of the Supreme Court was made over the company. Settlement Act 1781 in the year 1781, the Settlement Act was passed to remove the deficiencies of the Regulating Act. The judicial control over the company got removed by this act, and the systematic process was determined for making law. Pitt's India Act 1784. A board of control was constituted by the Pitt's Act. A board of control was constituted by the Pitt's India Act 1784, to whom all rights of control, supervision, and direction for the works related to all civil, criminal, and revenue of the land under the company's special courts were established for trial of offences caused by the British officers in India. The characters, the charters of the year 1786 and 1833. These charters have an important place in the legal history of India. An effort was made for codification of laws. By the Charter of year 1833. For this purpose, a law commission was also constituted. Lord Macaulay was appointed as chairman of this commission. A Lex Lossy report was issued by him. An effort was also made to constitute All India Legislative Council and All India Executive Council. The Government of India Act 1858. The Board of Control and the Court of Directors was abolished by the Government of India Act 1858 by ending the governance of East India Company. Under this act, the Government of India was made under the Queen, Viceroy, Governor General and Secretary of India were appointed for the administration. Legal administration and financial powers were vested in the Secretary of India. Indian Councils Act 1861. With the objective of decentralization of powers, the Indian Council Act was passed in the year 1861. Under this act, the legal powers were redelegated to the Bombay and Madras presidencies. The provisions were also made to establish council in other states. These councils may make laws with prior permission of the Governor General. Indian Council Act 1892, with the efforts of Viceroy Lord Dufferin, the Indian Councils Act was passed in the year 1892. The magnitude of Government of India was extended, its activities were increased, and efforts were made to increase the participation of non-governmental Indians in the Indian governance and administration. Indian Council Act 1909. The Indian Council Act 1909 is the result of reforms of Minto Marlowe. At the time of passing this act, Lord Minto was Governor General in India and John Marley was Secretary of India. The number of the number of members of Supreme Legislative Council was enhanced to 60 from 16 by this act. The provincial council were reconstituted. Indirect election system was commenced and the communal election board were shattered. The qualification of voters were defined. The Indians were allowed to participate in Indian Council and Executive Council, and also other arrangements were made by this act. The Government of India Act 1919. The Government of India Act 1919 is also known as Montage and Sword reforms. Commencement of diarchy is due to this act. Under it, the subjects were divided into two classes. One is transferred subjects and two is reserved subjects. The administration of transferred subjects was to be done by the governor with the help of Indian ministers and the administration of reserved subjects by the governor with the help of executive council. There are there were included in the transferred subjects local government, education, health, agriculture and industries. The following were included in the reserved subjects revenue, land, tenancy, famine, justice, police, prison, penal law and punishment process, etc. The central legislation was made of two houses by this act, Legislative Assembly, Legislative Council. The Government of India Act 1935. The Government of India Act 1935 had an important place in the legal history of India. By it, an old India Federation was established. Legislative powers were divided in three lists: federal list, provincial list, and concurrent list. To make law on the subjects of federal list, the powers were vested in central legislature. For the subject of provincial list in the provincial legislature, and for the subjects of concurrent list in the Governor General. A federal court was established by the Sheikh. The provisions for High Court for the provinces were made in this way during the year 1600 to year 1935. Many legislative and judicial changes were made. Direct effect of these changes on the existing judicial system reflects. These are considered important with a legal and judicial view for the reason of division of legislative powers, making two houses for legislature, codification of laws, establishment of federal court, establishment of high courts in the provinces, commencement of diety system, constitution of election boards, qualification of voters, judicial reforms, judicial reforms. After the persuasion of British judicial system, now we discuss the judicial reforms made during the British government. The main judicial reforms made during the British government are as under according to the decrees of year 1615 issued by Mughal Emperor Jahangir to Sir Thomas Law. The arrangements were made to settle the disputes of Britishers according to their personal law and process. Orders were also made for speedy disposal of the cases of Britishers. The courts of agents and council and Childry Court were established in Madras Presidency prior to the Charter of year 1726. The courts of agent and council were disposing of the cases of residents of White House and Childry courts were disposing of the case of residents of Black House. Let us take weakness. legal theory and human rights philosophy. Legal theory and human rights philosophy. Jurisprudence is the formal science of positive law. Holland explained. Holland has an important place in the series of followers of Austin. He attempted to present the definition of jurisprudence and law by Austin in extended form. Holland used the word formal science instead of word philosophy used by Austin in the definition of jurisprudence. He defined jurisprudence is the formal science of positive law. Thus, Holland has propounded jurisprudence as formal science of positive law. He, while considering the formal view of jurisprudence, has held it to be selected to prevalent rules of law, thoughts, and reforms. According to him, jurisprudence instead of physical rules is more related to human conduct governed by rules of law. It shall be proper to state that the word used positive law in the definition of jurisprudence by Holland is almost similar to the word used civil law is the definition of jurisprudence by Salmon. The positive law means those laws which are enacted by the state to regulate the civil relation and are implemented by the courts. Salmon has called such laws as civil laws. Holland has said jurisprudence the formal science because the jurisprudence does not study those rules which have originated themselves from personal relation. Rather, those relations are studied which are conducted by valid rules in serial form. The science is different from material science. Essential elements. Above analysis shows three essential elements in Holland's definition of jurisprudence. One is positive law, two is science, and three is formal. In simple language, we can place these three elements in following form that jurisprudence is positive law, formal science. What is positive law according to Holland? Positive law means those general rules related to the external behavior of human which are enacted by the state and are implemented by the sovereign political authority. Salmon has used civil law instead of positive law. Formal science. In this definition, Holland stated jurisprudence as the formal science of positive law. Holland says that jurisprudence is not the material science of laws equally controlled in different countries, but informal science of such human relation which has recognized legal consequences. In others, in other words, it could be said that jurisprudence does not study those rules which itself controls the legal relations, but studies the different relations which are controlled by such rules. Therefore, it is formal science. Roscoe found that while explaining the formal science of Poland, that the relation of study of jurisprudence is not directly with legal fiction, but it is with the method of legal fiction which changes the substance into format. Roscoe found viewed that Holland has not criticized the subject matter of law, rather has well organized the subject matter in accordance to analytical method. In its criticism, the definition of jurisprudence by Holland had been subject of criticism. The main critics had been Professor Gray Dr. Jenks and Buckland. The first element positive. The first element positive law of the definition of jurisprudence by Holland had not been the subject of criticism. The second element, formal science, has been the main subject of criticism. According to Professor Gray, the relation of jurisprudence with law is not merely based on the fact that what is the use of law, but is based on the fact that how should the law be used. Gray viewed that jurisprudence can mention even minute subjects or can be restricted to study of main general principle. The study of either of two can be called as jurisprudence. The requirement is that the book should be organized and scientific in which subjects have been duly classified and in series. Dr. James said that jurisprudence is not merely a form. Jurisprudence is not merely a form science. The truth is that the jurist can reorganize the law from its format, but after obtaining format, the jurist has to determine its meaning by minute analysis. Therefore, the consideration of jurisprudence has to be related merely to the format, reduces it from the level of science to merely a craft. Buckland criticizes the definition by Holland on following grounds. It is not proper to differentiate general and specific jurisprudence. It is not correct for Holland to believe that law is created by formulas like the geographical surface. Law is developed continuously, hence it cannot be compared to the science of geology, rather can be done with the science of zoology. But these criticisms are not very serious. Even this criticism, the definition by Holland is considered to be good. Austin has differentiated jurisprudence into general and specific jurisprudence, whereas Holland did not accept this differentiation. According to Austin's jurisprudence, general principles of law, notion, and distinction have been studied, whereas Holland had studied the legal relation created by human instead of the legal principles. Thus, the definition of jurisprudence by Holland is the form of definition by Austin. Cyber crimes. Let us discuss the various advantages of cloud computing. Cloud computing. Cloud computing is becoming increasingly popular due to its amazing features. It is becoming more prevalent in the business world. Its benefits include the following: scalability, flexibility, skill source, non-core activities. This is emerging as reality. This is emerging as a reality in the information technology industry, in which an environment of freedom from location is being imagined. Traditional computing was once considered a miracle. Today, cloud computing has replaced it. The multiplicity of computer resources on demand, the end of upfront commitment by the consumers, and the need to service and pay for it are the main features of cloud computing. Cloud computing is benefiting various aspects of human life such as industry, business, transportation, education, international security, and health services, etc. Following are the main advantages of cloud computing: freedom of access. Cloud computing provides significant cache of time free and space free access. It provides access from any end of the earth through internet connection. It is a public convenience system. It is characterized by cooperation and coordination. Sharing, modifying, and viewing of data are simplified as access is universal and is not restricted to a single location or region. It provides the facility of access from either office or home. Access is heterogeneous, which means it can be accessed through desktop, computer, mobile phone, and laptop, PDF, or TV. Scale, Scalability. The biggest feature of cloud computing is need-based quality. Due to this, cloud computing is gaining popularity. The usage and cost are proportional in this, so no question of extra cost arises. This feature of cloud computing is its goal, in which the tools are scalable and scaling based on the load of the consumer to the minimum role of the service provider through the API software. This allows for software self-integration and does not require user customization. Phase innovation. Applications and services are being used beyond the knowledge of cloud computing so far, giving new dimensions to computing such as mobile interactive applications that adapt to the location and environment. Their feedback is in real time, for example, worldwide weather data, etc. Parallel batch processing gives users the opportunity to benefit from high processing power to analyze terabytes of data in a short period of time, such as in the processing order of Google Pay reduce. The open source model Hadoop simplifies the parallel implementation of application spread across multiple servers. Business analysis mode on the one hand, such innovation which makes a lot of data available, it helps in establishing the identity of the consumer. Computer device desktop application which offloads the data located in the cloud and leaves the processed data in it. This work can reduce the disparity. Thus, the above mentioned three advantages of cloud computing are freedom of access, scalability, innovation. This, let us discuss tomorrow. Explain in details the internet banking services. What is the internet banking services? We will discuss tomorrow. Privileged class deviance and juvenile delinquency. Privileged class deviance and juvenile delinquency. Let us define medical malpractice and discuss the remedies available against medical malpractice. What do you mean by professional deviance in medical profession? Let us explain the remedies available to prevent the professional deviance in medical profession. There is a saying, first happiness is healthy body. For example, first happiness is healthy body, etc. The biggest happiness of life, healthy life. Only a healthy person can succeed in this life. That is, he can do anything. The patient cannot do anything. The patient cannot do anything. This is the reason that medical and health services have an important place in life. When a person becomes ill, he goes to the doctor for medical treatment. The doctor is like God for people suffering from helpless disease, as he gives a new life to the patient. The business of doctor is the only business in which a person or doctor can receive both money and fame. But when the physicians fall behind on the money, he cannot achieve fame. The matter of woman Narayan Bhiya versus State of Rajasthan AIR 2013 Rajasthan 35. It was held by the Rajasthan High Court that medical and health services are very important in life, even if it is not ordinary person. In such a situation, the liability of the doctor increases. In the matter of Malik Kumar Ganguly versus Sukumar Mukherjee AIR 2010 SC 1162, it was held by the Supreme Court that even a little carelessness of the doctor can endanger the life of the patient. Therefore, the doctor is expected to work with honesty, integrity, hard work. The same is expected in Article 25 of Universal Declaration of Human Rights, 1948 in the matter of Gita Sutra versus Kapoor Memorial Hospital, AIR, 2006 NOC 1111 Allahabad. It was shared that if a hospital does not have adequate equipment, it should not be taken up for medical purposes. In the matter of Purna Verma versus Ashwini Patel, AIR, 1996 of SC 2111, it was held by the Supreme Court that allopathic medicine should not be administered by a homeopathic doctor. In the matter of Permanent Kattara versus Union of India AIR 1989 SC 2039, it was held by the Supreme Court that in cases of road accident, the patient should be treated immediately by the doctor without falling in the legal formalities to so that his life is saved. In the matter Devi Janki Amma versus Union of India, AIR 2004 NOC 82 Andhra Pradesh, it was held that it is the duty of the doctor to treat the patient with utmost care. In the matter of Sushil Kumar Sharma versus State of Rajasthan, AIR 1999, Rajasthan 127, and Mukhtar Singh versus the State of Punjab, AIR 1999, SC 468, it was held that the doctor who is related to the medical system should be treated with the same medical method. In the matter of woman, Narayan Bhiya versus the State of Rajasthan, AIR 2013, Rajasthan 35, it was held that health and medical services are considered the fundamental rights of a person. Overall, it can be shared that medical and health services are very important services for life. It is the duty of a doctor that perform medical duties with integrity and honesty. Taking care in medical work, behave good, treat patients well, introduce sensitivity. Do not take unnecessary funds from patients. Make medical work a priority. Treat yourself in your specialist medical practice. Medical malpractice, but it is unfortunate that today medical practitioners are getting distracted from their official duties and responsibilities, that he careless about his business, he takes bribe, he performs therapy after recovering a huge amount, he issues false medical evidence, prepares false postmortem report, charges money from medicines, charges money for simple medicine, makes illegal abortions, makes gender test, practice with fake degrees. He moves away from his expert method to another method, treats patients abusively, acts as charlatan. He absents from his duty. He does his private practice illegally. These all are medical malpractices. It is called professional deviance. It is called professional deviation. Indian Medical Council controlled them. Indian Penal Code 1860 appropriate punishment has been provided for this. Gender testing is the gender testing is considered an offence punishable under the preconception and prenatal diagnostic techniques. Prohibition of general selection. Sector Act 1994. Cases of medical malpractices. There have been many cases of medical practices in the courts in which heavy amount of penalty has been imposed on the guilty doctors. The state is also considered a vicarious liability. In the matter of Puran Verma versus Ashwin Patel AIR 1996 SC 2011, it was held that Puran Verma's husband died due to allopathic treatment by homeopathic doctor. Supreme Court ordered rupees 3 lakh compensation from doctor to Puran Verma. In the case of Shanta versus State of Andhra Pradesh, EIR 1998, Andhra Pradesh 51, it was held that during surgery, due to carelessness of the doctor, some material left in the woman's stomach, due to which she had to undergo surgery again. The Andhra Pradesh High Court, believing it to be the negligence of the doctor, ordered a compensation of rupees 3 lakh to the aggrieved party in a matter of S. Sri Narendra Singh versus R.D. Sood, AIR 2003, Jammu and Kashmir 20. It was held that it is the duty of the doctor to take all precautions before and after surgery. In the matter of district health officer versus Sothari, AIR 2012, Madras 207. It was held that a school-going boy was given a lot of vitamin pills by a government health worker, but no instructions were given regarding its consumption. The child had 30 tablets at once, which led to his death. The court ordered compensation for the state government, assuming it guilty. In the matter of Surajmal Chamd versus State AIR 1999, Rajasthan 82, it was held that petitioner's young daughter, Dr. Veena, died due to hepatitis due to lack of necessary equipment in the hospital. The court considered the petitioner to be entitled to civil action for compensation. In the matter of Haridev Nargotra versus Sandoz India Limited AIR 2003, NOC 206, Jammu and Kashmir. It was held that before giving medicines to any patient, it is the duty of the doctor to check the medicine. In the matter of Satya versus Shashi Sharma AIR 2003, Jammu and Kashmir 41, it was held that at the time of surgery, it is the duty of the doctor to see that there is no external substance left in the patient's body. Thus, there are many other cases which throw light on medical malpractice. Dear friends, tomorrow we will discuss what is the professional deviance in journalism, what is the role of press council in preventing the professional deviance in journalism, right? Not on press council. That we will discuss tomorrow. Now let us discuss panology and victimology. What are the different theories of punishment? Which one of the theories do you prefer? It is said about punishment that it is said about punishment that uninvestigated criminals are an expensive luxury. This statement is correct. The punishment is directly related with crime. The punishment is given according to the nature of crime while awarding punishment to the criminals. The surrounding circumstances, anything assist in commitment of crime, circumstances under circumstances under which crime has been committed, conduct of criminal is consigns the conduct aggrieved party has party his status. They all determine the form and quantum of punishment. Many times crimes are committed under compulsion and adverse circumstances. The criminal has to repent afterwards on his act. The strength of reform arises in him while passing order for punishment. This thing has also to be taken into account. Further, this is also one aim of punishment that the severest possible punishment should be given to the criminal so that crimes may be prevented, terror may be created in the society, and nobody may dare to commit crime. In the matter of state of Madhya Pradesh versus Kashiram AIR 2009 SC 1642, the Supreme Court held that the punishment should be in accordance with the crime, considering the severity of crime, cruelty and atrocity. The quantity of punishment should be assured. Punishment should be such that can provide relief to the distressed society. Considering all these things into account, some theories of punishment have been propounded. The main theories are as follows: deterrent theory, preventive theory, retributive theory, expiatory theory, reformatory theory. What is what is deterrent theory? This is the oldest theory of punishment. Its main objective is to keep separate the criminal from the crime by terrorizing him by means of punishment. In addition to this, its objective is to terrorize the other person in the society so that they may remain separate from crimes. Thus, the main objective of this theory is to check crimes by means of terror or punishment. The main assumption of the supporters of this theory is that the criminals should be given very rigorous punishment, torture, etc., should be given so that the criminal himself and the whole society may become terrorized and may not dare to commit crime in future. Though this theory is practiced in some countries, but it has been criticized by many criminologists. The critics have said that the crime cannot be checked by means of punishment only. From severe punishment, the possibility may exist of increasing rather than reduction in crime. The critics treat it as barbaric and cruel, and therefore it has no place in the present system of punishment. According to Dr. Sethana, only the severe punishment is not the only means of prevention of crime because many times the criminal becomes habitual while tolerating punishment. Therefore, to check crime, some compensation must be imposed upon the criminal. Sutherland is of the same view. According to him, many criminals do not think over punishment, even they are not under terror because they have defective mentality. Many times crimes are committed under sheer excitement and emotion which have no relation with the forms and quantum of punishment. What is preventive theory? This theory is of most rigorous type. The objective of this theory is to make the criminal disabled and to provide security to the society. The supporters of this theory have to say that the criminals are formed for a society. They create chaos and insecurity in the society. Thus, such criminals should be kept separate from the society. The following forms of punishments are proper for them: death penalty, lifetime imprisonment, and banishment. This theory of punishment is based on the maxim that prevention is better than cure. Instead of taking revenge on the criminal, the crime itself should be prevented. The famous jurist Fichte had said that the purpose of all the penal method is that they do not have to apply them. It means that the purpose of punishment is to spread fear among the people so that they do not commit the crime, and when they do not commit the crime, then there will be no opportunity to enforce the penal code. Bentham and Mill are the strong supporters of this theory. According to them, the death penalty is awarded to the criminal not on the basis that he should not commit crime in future, but it is given so that such people can be liberated from the society. This theory is also subject to criticism. The critics say that how long a criminal may be kept separate from the society. On some day he will be come out from the prison. After coming out he will not commit crime. It cannot be guaranteed. So this is not the last resort from crime prevention. In spite of this, the forms of punishment, death penalty and lifetime imprisonment have been given important place in the penal system of various countries. Retributive theory, it is also known as revengeful theory. The main objective of this theory, the main objective of this theory is to take revenge from the criminal. The main idea lies behind the theory is that as you sow, so shall you reap. The basis of this theory is that life shall go for life, hand for hand, and foot for foot, eye for eye, and tooth for tooth. According to P.K. said, the main goal of this penalty is to take evil from evil without worrying about the consequences. Plato says that justice is the goodness of soul and health, and injustice is illness and evil, whose remedy is punishment. In the words of Bradley, the relation between criminal law and revenge is such as it is between marriage and affection. According to Sir Walter Moberly, the main objective of retributive theory is that the criminal get punishment for his wrongful act. Punishment is necessary for a healthy society, even if the society does not like it. Sir Walter Moberly, the ethics of punishment, but some critics have criticized this theory. Salmon said that revenge is not the remedy of crime, but cause of increment in crime. Other critics consider it as the punishment of very low or degraded nature. Along with criticism, some thinkers have supported this theory. In the opinion of Dr. M. Z. Sethana, the goal of the retributive theory is not the result of retribution but the result of consequences. Professor Keaton thinks this theory Professor Keaton thinks this theory is ethical. His view is that this theory is relevant in the changed context of today. Next, last 5 is 4 is expiatory theory. This is the principle of self-purification of the culprit. Because crime is considered to be sin here, therefore atonement is necessary for the purification of sin. Actually, these do not have any legal theory because it is based on religious beliefs. It has no legal effects. It is not necessary that the offenders should not be penalized after the atonement. What is reformative theory? This is the modern theory of punishment. The main objective of this theory is to give the chance to the criminal to reform. It clears the way of the society after reforming the criminal. It is based on the maxim hate the crime and not the criminal. The man is not criminal by birth. It is circumstances which make him criminal. Poverty, emotion, compulsion, and family atmosphere are such causes which make a man criminal. After commitment of crime, The criminal repents upon his acts many times. He wants to reform himself, keeping all these things into account. The reformatory theory has been avoided. According to this, a criminal is not awarded the punishment of imprisonment, but is given the chance to reform himself by means of following probation, admonition, parole, keeping in reformatory house, to pay remuneration for the work done and rehabilitation, etc. Bentham, Ferry, Fellow, and Walter Reckless are the strong supporters of this theory. They are hopeful of prevention of crime by means of this theory. Sutherland is also supporter of this theory. In Shivaji versus State of Maharashtra, 1972, Criminal Law Journal, 1783, SC, Justice Krishna Iyer considered present penal system as not suitable to the present society and recommended reformatory theory of punishment. The theory has also been criticized according to critics. The terror of punishment is necessary for prevention of crime. There is a strong possibility of misuse of reformatory system. The reformatory measures cannot prove successful for habitual offenders, and the effect of this theory may be experienced only on juvenile delinquents and emotional criminals. In an American report titled Struggle for Justice, it has been said that the reformatory theory is nothing except a show. The main objective behind adoption of this theory by prison authorities is to increase their powers. In its conclusion, we can say from the above, it is clear that each theory has its own advantage and disadvantage. In the present context, no single theory can prove successful. For prevention of crimes where punishment is necessary for creating terror, the criminal should get the result of his act. Along with this, if the crime had been committed under compulsion, emotion, and if he expiates for that, he should be given the chance to reform himself. Therefore, it is desired that a universally accepted theory of punishment should be evolved which may take into consideration the surrounding circumstances, age, character, nature of crime, and spirit of reform. Dear friends, tomorrow we will discuss capital punishment while pretending to support reverence for human life does in fact tend to destroy it. Do you spot with that penalty? We will discuss it tomorrow. Let us take a short break, please. Now let us discuss criminology and criminal justice administration. Let us discuss briefly the Sutherland's important contribution to criminology. Do you know about Sutherland's contribution to the modern criminology? The name of Sutherland in criminology is considered as very important. He is considered as father of sociological school of criminology. His contribution in the development of criminology is beyond comparison. Sutherland Sociological School of Criminology. The sociological school of criminology is the most developed theory of modern age. Sutherland is considered as the father and strong supporter of this theory. Sutherland defines criminology as a branch of knowledge which treats crime as a social event. Three types of procedures are included in this social event. One is law-making procedure, two is procedure for violation of law, three is social reaction as a result of violation of law. Under the first procedure, scientific analysis is made of those circumstances under which criminal law is enacted and which development takes place. This is known as sociology of law. Under the second procedure, all procedures of violation of law are included. Despite the prohibition of crime, a group of society violates criminal law. Criminology discusses and analyzes all these causes on scientific basis, which are at the root of criminal conduct. This is known as causative theory of crime. Under the third procedure, the reaction is made by the individual, society, and the state on commitment of crime. This procedure is expressed by way of penal action. The branch of knowledge of criminology which analyzes this reaction is known as penology. Sutherland is of the view that criminal conduct arises from those procedures from which other social conducts arise. The analysis of these procedures related to the criminality have taken mainly in two forms. Firstly, the sociologists have tried to link the difference in rates of commitment of crime with all institutional methods with change in social organization. In societies or sub-societies, in respect of change of rates of commitment of crime, some social conditions have been described, some of which are procedure of mobility, cultural contradictions, competition, standardization, religious, political and economic ideology, density of population and organization, and distribution of wealth, income, and planning. Secondly, the sociologists have tried to analyze those conditions under which a man becomes criminal. These analyses were related with the normal principle of social learning and used the concept of adoption, tendency, values, distribution, association, and to some extent the effect of despair and compensation. From the above analysis, it is clear that the main assumption of Sutherland was that normally the crime is a learned behavior. He said that the crimes are not invented, but they are learned. A man who accompanies the type of people he does the same type of work. The person conducts in the same way as the other does in association with him. Sutherland's theory in respect of criminal conduct, the theory which was developed by Sutherland for analysis of criminal conduct, is known as theory of differential association. In reality, this is historical interpretation of criminal conduct. The criminal conduct is a result of learning. It cannot be hereditary. The criminal conduct is learned in association with other person by way of action reaction. The main part of learning of criminal conduct takes place among well-known groups of persons. Many things are included in the learning of criminal conduct. Technique of conduct of crime, motives, wishes and attitudes and special directions therefore. Special direction for motives and attitudes is learned from the favorable and unfavorable definition from legal courts. A man becomes criminal when the definition of violation of law is more favorable or beneficial for him as compared to the definition of violation of law which is unfavorable. This is the theory of differential association. A person becomes criminal in association with criminals or criminal tendencies and separation from non-criminal tendencies. Differential association, continuity, time period, clarity and fitness, they can be separated from each other, etc. If a man comes into contact continuously with criminal conduct, then they may become criminal. Similarly, if a person comes into contact with non-criminal association continuously, he may develop non-criminal conduct. The conduct which remains persistent for a longer period remains effective and affects men. In association of criminal and non-criminal conduct, the same instincts remain present in the learning of criminal conduct which remain in learning of other things. Though criminal conducts are expressions of normal needs and values, but they cannot be interpreted by normal needs and values because non-criminal conducts are also the expression of same needs and values. Thus, by development of criminological theory, Sutherland has given new direction to the causative theory of crime. In its criticism, Sutherland's theory is criticized by saying that the differential association is not important in itself. In reality, it takes shape of that opportunity in which personal traits are expressed which are embodied in personality. This theory does not explain this fact that a person who remains in particular association or atmosphere forms this conduct as criminal while the other person remaining in the same atmosphere does not. There are many criminal conducts which are formed suddenly and they have no concern with learning. According to George Gold, if crimes are analyzed with the theory of differential association, then it goes far off from the boundary of reality because it is difficult to think of crime in association with any power. Crime in reality is a byproduct of many causes. The only common thing is the violation of criminal law. Despite all this, Sutherland has given new direction to the criminology and tried to make it objective and scientific. Dear friends, tomorrow we will discuss, define the term crime. What are its essential elements? We will discuss it tomorrow. Now, last but not the least, legal education and research methodology. Describe the object of the legal education. In democratic welfare state, the importance of legal education is proved in the rule of law. Law education cannot be neglected. The individual being the unit of society, social welfare is merely a shorthand description of the welfare of the individuals. In this condition, importance of legal education increases. A legally educated person can discharge his role in many fields like as an administrator, an advocate, rule maker, law professor, as an businessman, etc. Many other fields are also open for a law educated person. It also clears the object of legal education. The object of legal education is very wide. Legal education means education that is legal, etc., related to law. We also can say that study of law is legal education. Legal education, simply defined, is education that is legal. It must be noted that the main objective of education generally is to effect national development. The study of object of legal education can be done under following heads. One is on knowledge of law. The first object of legal education is to earn knowledge of law. Person get aware about the national and international law during legal education. Knowledge of law is necessary in the rule of law. Their ignorance of law is not excusable. Ignorantia juris non excusable. Ignorance of law is not excusable, etc. Ignorance of law is not excusable. God presumes that every person has knowledge of law. No one escapes by taking excuse of ignorance of law. It is appropriate also if ignorance of law would be excusable, then everyone will escape by taking benefit of ignorance of law. That's why knowledge of law is important for every person, and it is possible by legal education only. Legal education aware a person regarding his rights, duties and liabilities, making a competent advocate. The second main object of legal education is to prepare a competent advocate. Advocates are an important part of society. They have their own place in society. As an advocate, he pleads in court on behalf of his parties, defend the rights and benefits of parties, protect the fundamental rights of person, work for progress and development of society, discharge an important role in the development of society and nation, provides free legal aid to weaker section of society, free legal consultancy to indigent and incapable person, and ways to solve the matters by mutual compromise, develop legal awareness in public, such as an advocate provides his services to society as a multi-dimensional person, but it only possible when he is well educated or trained in the subject of law. Legal education helps to produce a competent lawyer. It has been noted that a competent lawyer, in accordance with general education policy, is presumably someone who has acquired appropriate skills, abilities, and competence, both physical and intellectual, as required for her to play her role as a useful member of community. The ultimate object of legal education, therefore, is to produce competent lawyer whose aid in any given society, including the defense of fundamental rights of individuals as well as their welfare, according to inhering. Lawyers are concerned generally with law, And the purpose of law, according to inhering, is to further and protect the interest of society. Prepare person for critical legal education. In this, in this changing time, the concept of justice has also changed. Now, justice is not only of rich people but also possible for the indigent and weaker section of society. In Article 39A of Constitution, provision has been given that no one shall be deprived from justice on the basis of poverty or any disability. To achieve this aim, legal service, free legal act, legal literacy, lok adalts were established. Gradually, clinical legal education came into knowledge to provide legal advice and legal help in legal clinics, advocates, professor of law, students, and social service provides their services. In this way, trend of clinical legal education increased. Now it has been also become an object of legal education to prepare such person who can who can provide their services at clinic. To make a good citizen, the object of legal education is not only to prepare advocates but also make a good citizen who can further serve his nation of society. It's not important to become an advocate after getting law education. You can also serve your country and society by being a good citizen. In today's industrial or computer era, the importance of legal education is increasing day by day. In every field, there is interference of law. In field of medical, also there is medical law. Similarly, in engineering, agriculture, or industrial field, also now there is presence of law. Now, the concept of law in social engineering is also in existence. Such as area and importance of legal education is increasing day by day, and its objects are very wide. Object of good legal education. One is a good understanding of the structure and goals of the society, a good understanding of the nature of the lawyers, a good understanding of some of the general rules and principles of law, a good understanding of some rules relating to special transactions or activities of the society, a good understanding of methods and techniques. Dear friends, all my brothers and sisters, ladies and gentlemen, students, scholar, teacher, trainer, professor, professionals, the most honorable present Mr. Modi, respected doctors and directors, honorable minister managers, honorable advocates and administrative advisors, I would like to thank all of you. Tomorrow we will describe the contribution of institution in the development of legal education.